Good afternoon, everybody. Thank you for joining us for what I think is our fourth weekly webinar that we've been putting out for you all, for our clients and friends and community members. My name is Jamie Dreher. I'm a partner at the Downey Brand Law Firm. I'm a commercial and finance and commercial bankruptcy lawyer. I've been moderating some of these panels. I don't anticipate that I'm going to be providing much content today, but hopefully the content we provide is of interest to you and helpful in some regard. If you could all, just to be sure, we think we have it covered, but on your end, place your microphones or your phones on mute for us, please. During the webinar and during our presentation, we will be able to, in some fashion, take questions. So at the bottom of your page, there should be I believe it's in blue, a chat icon or a chat box. Just click on that and you can send questions directly to Mary Isley, who's the host of the webinar. Alternatively, you can click on everyone and everybody will see your question. We're going to try to catalog them. Towards the end of the hour, we'll get to what we can if we have some answers or address them just for a few minutes, but please feel free as things are happening to shoot in those questions. We are cataloging them here internally. Before I introduce today's panel, just a little bit of a heads up. I noticed today that many of our registrants are in the food and agricultural space. And what you may not know, but what we are planning on doing is a week from now, we are actually having a food and agricultural industry-specific webinar on which we are going to touch on a lot of the issues relevant to your businesses and your concerns, but industry-specific. So we're going to be focusing on the food processing industry, grocers, and food manufacturing and distribution next Friday. That discussion is going to be led by Dale Stern, who is the chair of our food and agriculture group. So today's panel, I'll just kind of briefly talk about the agenda before turning it over. We're going to hear from our employment law partner, Liz Stallard, who, if you tuned into some of our prior webinars, you may have heard from. She's going to provide some updates on some relevant employment and workplace issues that are, kind of happening and changing on a daily basis. Following Liz, Steve Hymas from our corporate group is going to do a deep, detailed dive into the Paycheck Protection Program, which we briefly spoke about and hit on last week, but Steve is going to delve into some of the detailed questions, a lot of which we received in advance, some questions we received after last week's webinar. Steve is then going to turn it over to our litigation partner Amy Amaral, who is also chair of our healthcare litigation group, and she's going to be talking about more generally litigation, issues in the courts, what's happening with cases, and things like that. So without further ado, I think that's all I had, so I will just turn things over to Liz.
Thank you, Jamie, and good morning, everyone, or good afternoon, I should say now. As Jamie mentioned, my name is Liz Stallard. For those of you who don't know me, I'm a partner in the employment and benefits practice here at Downey Brand. And today I'll be going through a couple of the issues, and thank you, those of you who sent in some questions before the webinar. It helps me to figure out things that matter to all of you. And so we'll be walking through some of those key topics for my presentation this morning. And the first of those topics is about masks and whether or not, or how you as an employer should address the issue of wearing masks in the workplace. And obviously this is something that we've been hearing a lot about in recent days. I even spent some time this morning making some fabric masks of my own. I think a lot of us are thinking about, whether we need to be wearing them at home and at work and everywhere else. So the first thing to think about, and the first thing I want to make clear is I'm going to speak generally about mask requirements in the workplace. Certainly there are certain industries and other respirator requirements under Cal OSHA, and otherwise I'm not going to get into that today. I'm just going to kind of try and focus on general industry requirements for masks. And at that level, there isn't currently a mandatory mask requirement. However, I do think it's worth noting that earlier this week, Cal OSHA issued some guidance with respect to potentially exposed essential workers. And what I think is interesting about that is, first of all, Cal OSHA's guidance provides guidance recommending what to do if you have an essential worker that may have been exposed to COVID-19. And even in that guidance, it says that that individual, among other things, should wear a face covering at work. The reason I think that's important is also that Cal OSHA even recognizes that face covering is not necessarily a surgical mask or an N95 respirator. As you've probably heard in the media and elsewhere, those are in short supply, and the general expectation or the focus of a lot of these recommendations is not to tell people out in the public who don't otherwise have a work requirement to wear them to be wearing those kinds of masks. I think that's consistent with what we see in the Cal OSHA guidance, which is they're talking about face coverings and not necessarily surgical or N95s. Of course, we also know that the CDC has now recommended that all individuals wear some sort of cloth face covering or other mask when they're out in public. Again, to stress, it's not a surgical mask or an N95, but we're talking about some form of face covering, right? And again, there's descriptions in the CDC guidance. They talk about things made at home. Again, people are sewing their own, or they're making them from their scarves and, and bandanas and other things like that. And of course, the state of California has followed suit, and also our Department of Public Health is recommending that, basically saying we recognize that local governments are going to come around and start addressing issues of whether or not people need to be wearing face coverings. There isn't a whole lot of specific information coming out of the state of California, but that being said, and as you perhaps have now seen, we do have localities that are taking the effort into their own hands. Most recently, we have the city of Los Angeles that has now ordered all people, including essential workers, to wear them starting Friday. And we have the county public health officer in Riverside County who has already ordered all residents to wear face coverings in public. The reality is, as we saw with shelter-in-place orders and other efforts to mitigate the spread of this virus, I wouldn't be surprised if we start seeing more and more local entities doing very similar things to what we're now seeing start in Southern California. And the reason I think that's important is because, as you may also remember, when these things started rolling out across the state, they tended to copy each other in large respect. And so I did want to take some time to walk through with you what those local mask orders require in LA and in Riverside County, because if you're thinking of implementing some sort of mask program at work voluntarily for your employees, or if you have your employees asking you, can I now start wearing masks at work? I want you to be prepared to put something in place that, at least right now, is likely to be consistent with what you may have to do anyway if a mandatory program is instituted. So the requirements that we saw coming out of those local orders, essentially that the employer, if the worker is required to wear one, the employer either provides that face covering or reimburses the employee for it. That's basically the tendency in that. These orders have recognized that they're not, again, surgical or N95s, but they can be fake fabric coverings like scarves or bandanas. And the guidance will stress that the coverings need to cover noses and mouths while the employees are performing their work. And then finally, that the coverings need to be washed frequently at a minimum of once a day. Again, this isn't a current requirement statewide, but I think if you've been rolling around whether or not you want to put something in place, I think you should consider what has already been mandated when you're crafting your own voluntary policy. And then the last thing I'll tell you is, while the California Department of Public Health hasn't really said a whole lot of specifics about how to deal with the masks, they do have some pretty helpful guidance on their webpage about face coverings, and we'll go ahead and we'll make it available on our webpage at the end of all of this. I think it's useful because it explains things like, this is not a substitute for social distancing and for washing your hands and all of the other things that we've been doing. And the guidance also explains, when you're using face coverings, how to use them effectively, what they're good for, explaining that it's to prevent individuals who may be sick from spreading it to others. All of those kinds of general bits of information that if you are going to start having your employees wear masks, or even if your employees are asking you whether they should be wearing masks at work, I think you should have this information handy and share it with them and make sure that they understand what these masks are really likely to be able to do. So with that, I'll move on to the next topic I have for today, which is best practices for taking temperatures in the workplace. The EEOC, our federal employment agency, has issued updated guidance with respect to taking temperatures in the workplace, specifically to address issues associated with COVID-19. So unlike some of the things we've been dealing with, where we've been trying to tea leaf through what used to be in place and see how it applies to COVID, at least the EEOC has confirmed that this is how they want temperatures to be addressed in the context of COVID-19. Let me also say again, there are some local entities that have imposed certain temperature taking requirements, either industry specific or otherwise. And so again, What I'm talking about is not specific to anything like that, and if you may be covered by something like an order or a requirement, it's really important that you understand whether you're covered and what it may require, because generally speaking, it's going to require more than just what the standard EEOC guidance allows. And so that footnote, just to make sure you know if this is something that you need to personally address. Now, of course, generally speaking, the ADA, the Americans with Disabilities Act, prohibits you from making disability-related inquiries or medical examinations and inquiries unless they're job-related and consistent with business necessity. And that's usually the blocking point for employers when digging into health information about their employees. However, you can go ahead and do it when you have a reasonable belief based on objective evidence that the employee's ability to perform the essential functions of their job may be impaired by the medical condition, or if that employee represents a direct threat due to their medical condition. And the punchline of this is that the guidance coming out of the EEOC, relying on the CDC and other public health information, is that we are going to assume COVID-19 has been confirmed to be a direct threat. So that gives you the ability to seek these medical examinations. This same analysis about whether or not there's a direct threat is also what applies to guidance that you've been given probably already about whether you can send employees home if they are exhibiting symptoms, or if you're allowed to, inquire into your employees who are exhibiting symptoms to figure out whether or not they might in fact have COVID-19. So again, because we have this confirmation that COVID-19 is considered a direct threat, you can go ahead and take the temperatures of your employees in the workplace. Of course, and as always when we deal with medical information related to employees, the results of that test and the information about your testing efforts have to be kept confidential with respect to the employee, and that's your standard ADA obligation that has not been lifted or, lessened in any way because you're allowed to do these temperature tests at work. So if you are thinking that temperature tests at work make sense for you, again, I wanted to give you kind of some principles to think about as you may be setting up that program. The first is, of course, you want to tell your employees that you're planning to do this, explain to them in advance that you're going to start taking temperatures or however you're going to set up the mechanics of it so that no one's surprised when they show up to work, so you don't end up with a backlog of people who aren't socially distanced, maybe waiting to get their temperatures taken, all sorts of logistics that should be explained so your employees know why you're doing this and that it isn't targeting anyone, specific or that you're doing this to keep everybody generally safe and healthy. I also think it's important because people may be nervous about reporting symptoms if they think there's a consequence, that you be prepared to talk to them about things like the emergency paid sick leave that may be available to them if, as a result of this test, they then have to go and seek diagnosis for COVID-19, right? So people aren't as afraid as they might otherwise be to tell you that they're sick and shouldn't be coming to work. The next thing to think about is setting a base threshold above which or at which you send everybody home. CDC believes that or confirms that a fever is 100.4 degrees or 38 degrees Celsius. That is probably the best benchmark to set for your temperature threshold, although I've seen some anecdotal evidence online that some employers are setting it a little lower, like at 100 degrees. Digging into that deeper, I think the 100.4 is safe because that's what the CDC says. And then, of course, you want to be indiscriminate, right? Everybody who hits that gets sent home and that you have an identified standard in advance, again, to make sure that you're consistently applying this. And then the last thing, as I mentioned earlier, is you want to think about how to implement this program in a way that not only maintains confidentiality for your employees, but also maintains safety, right? And so making sure that the way you have it set up so they take the test is efficient and safe, right, that people are effectively distanced from each other, that you have someone taking the test that has the appropriate protective gear and knows what they're doing, that you're using the right kind of devices and you're cleaning them frequently enough to keep people from getting sick. All of those things that you'll need to kind of flesh out as part of this program to make sure that you're doing it the best way that you can. And of course, again, with respect to confidentiality, making sure that those results are kept confidential with respect to each employee. And of course, part of that is going to matter how you do the test to make sure that others can't hear the results or perhaps hear you determining, whether or not someone has triggered the temperature requirement. And so with that, the last question I have, and this will be fairly brief, is the question about whether or not you as an employer still have an obligation to address reasonable accommodations for your employees if they are teleworking. No surprise, the answer is, of course, yes. If you've sent an employee home or they are home working for you and you have made a reasonable accommodation for them when they're working on your site, you have an obligation to provide that same reasonable accommodation for them unless you can demonstrate that it's an undue burden. And so what does that maybe mean? Maybe you have an employee who at work needs a screen reader or some sort of other adaptive technology in order to participate in calls and in work-related matters. You may need to make sure that if you've sent everybody home and they're working from their home computers, that that employee has the same technology. Again, this is going to be pretty specific to the employee, but I just want to remind everyone that you shouldn't assume just because they're home that they have all the resources they need to now work effectively. And you may end up having some of these conversations with your employees, particularly as teleworking goes on for an unknown extended period of time. And the last thing I will say is there is some guidance on the EEOC page that they appreciate that right now it's a challenging time and employers are fielding a lot of requests, and they give kind of a generic, but we hope that employers work to resolve these issues as quickly as they can. I would say that obviously you have priorities in the workplace, and maybe a number one priority may not be sourcing a particular piece of equipment, but those are the kinds of questions that if they come up with an employee, reach out to us or reach out to somebody to kind of walk you through what your options may be, just to make sure that those things don't fall by the wayside right now as you're dealing with kind of the more urgent and imminent realities of dealing with COVID-19. And with that, I will end my portion of the presentation and turn things over to my partner, Steve.
Loan programs available through the CARES Act, especially the Payroll Protection Program, or the PPP, and the Economic Injury Disaster Loan Program, or the EIDL. Since we have some attendees that have attended in the past and heard some of the information, I wanted to give some additional detail and updates and answer some of the questions that were provided. But for any of the new attendees or people that want more information, I also wanted to give more of a background and detail on the programs. And so for the first program, or the Payroll Protection Program, or the PPP, this is a program that provides a low-interest loan for businesses with fewer than 500 employees or businesses that meet other qualifications listed by the Small Business Administration, or the SBA. Some of these other qualifications, other than the 500 employee requirement, are some extra rules that they have in place. For instance, if it's a business in the accommodation or the food service industry that has 500 or fewer employees by location, that would qualify. If it's a business that is a franchise and assigned a franchise identifier code by the SBA, that would qualify. Sole proprietors and other self-employed individuals qualify. And then some tax-exempt organizations like 501c3s also qualify. One question that some clients have asked is whether the SBA affiliation rule applies with respect to the PPP. And for background, the SBA affiliation rule basically requires a business that has affiliate entities to count those employees in the affiliate entities in determining whether it qualifies for an SBA loan. So if somebody is applying for an SBA loan, it would take into account the employees at the affiliate entities as well. According to the SBA, that rule does apply for the PPP. However, it also states that if that provision is waived in the Act, then the requirement won't apply. And the waivers that are listed in the guidelines from the SBA are basically that if it's a business in the accommodation and food service industry that I just mentioned, and they meet the 500 employee or fewer requirement, that would be waived. If it's a franchisee and the franchise and it's in the franchise directory, that would be waived. And then any business that receives funding from a small business investment company. The next element I wanted to talk about is basically the criteria on the loan that you would get if you qualify as a business entity. And under the program, a qualifying business is entitled to borrow the lesser of either the average monthly payroll costs calculated over the previous calendar year and then multiplied by 2.5 plus any amount refinanced under the EIDL, or $10 million. Now, with that definition, there's been a lot of questions about how you can calculate the payroll costs. One part of the question is about whether a business should include independent contractors in the calculation. And according to the SBA guidance that we've received, independent contractors do not count as employees for a borrower's PPP loan calculation. The next part of the question is what do you include in the calculation of the payroll cost? And again, according to the SBA guidance that we've received in the interim final rule, payroll costs include wages, salaries, commissions or tips, vacation, family and sick leave, allowance for separation, employee benefits like group health coverage, and state and local taxes assessed on compensation. Therefore, you would want to include those elements in your calculation of the payroll cost calculation, but not include non-cash benefits. Furthermore, you have to cap your calculation at $100,000 per employee. Therefore, when you're adding up your payroll cost calculations for each employee, you should subtract any compensation paid to the employee that exceeds an annual salary of $100,000 to come up with your payroll cost calculation. And then another question with regards to this payroll cost calculation is what happens if you weren't in business in the last 12 months? And again, according to the SBA guidance, if you weren't in business for the last 12 months, you can use the average monthly payroll starting from the period beginning January 1st, 2020 to February 29th, 2020. Some other elements in addition to the calculation of payroll costs that are part of the loan include the fact that there is no requirement to evaluate a borrower's ability to repay the covered loan. The SBA will allow lenders to rely on certifications of the borrower in order to determine eligibility. There's no guarantee required, which means that loans don't require or permit collateral or personal guarantees as part of the loan, and there's no recourse. So there's no recourse against the borrower unless the borrower uses the loan proceeds for an unauthorized purpose. And then tied to this recourse issue is the issue of forgiveness. And it's something that would be important to plan right now. A lot of businesses that they're focused in primarily on getting the loan right now. However, it's important to remember that SBA will forgive loans that are given, provided that certain conditions are met. And so it's important to plan now to help ensure that you're following those criteria and that the loans can be forgiven. And basically, there's 4 criteria that need to be met for the loan to be forgiven. First, the business must use the money for applicable uses during the 8-week period. These uses include payroll costs, rent, utility, and interest on mortgages. And therefore, you need to make sure that you're putting in a good program to track how you're spending with these applicable uses to make sure that you're in compliance. One suggestion I heard is for the business to set up a separate bank account and only withdraw funds from that account for the applicable uses to show that you basically held on to those funds and only used them properly. And then the other element that you should do in either case is to make sure you're documenting your spending to show that you spent your money on the applicable uses. Another criteria that SBA will look at is employment. And the SBA will look at the employees on the business's books during the 8-week period and compare it to the pre-COVID period to see how many were retained. If the business retains 100% of the employees, then the business is eligible for 100% forgiveness. If the number is less than that, then only a portion of the loan will be forgiven. However, a business can cure this if by June 30th, 2020, the business eliminates its reduction in employees. The next criteria is wages. And here the SBA is going to look at whether the business is paying employees at the same rate. And as long as the business is paying at 75% or more of the pre-COVID wages, then there won't be an adjustment. And this is calculated for annualized wages over the period of 2019. The next criteria after that is whether the business spent the majority of the money on payroll. And here, the SBA is going to look at whether 75% or more of the loan proceeds have been used for payroll-related items. A business can only use a quarter for non-payroll items like utilities and rent that we mentioned. And then for any portion of the loan that is not forgiven, it will carry a 1% interest rate, and the loan will be due in 2 years. For loans that were issued during this period through June 30th, 2020, the payments on the principal and interest are deferred for 6 months. And so those are the basic background elements of the Payroll Protection Program, and I'll answer a couple questions that we received about that in a second. But next, I wanted to discuss the Economic Injury Disaster Loan, or the EIDLP. And this hasn't gotten as much discussion as the PPP, but it's another loan program that's available through the CARES Act. It's an existing program, but honestly, it was extended and broadened under the CARES Act, and it's another source of funds that may be available to a business. And under the EIDLP, a qualifying organization can receive up to $2 million in loans to be used for working capital and other expenditures. So the approved uses are broader than the PPP. And to be eligible, the organization will be determined eligible by the Small Business Administration, depending on the number of employees, average sales, and other standards set by the SBA for their industry. The loans are available to borrowers that can show that they're unable to meet their existing financial obligations as a result of the COVID crisis. So that's part of what you'll have to document as part of the loan. And then the interest rate on these loans is 3.75% for small businesses and 2.75% for nonprofit organizations. To apply, instead of going to a lender, you can apply directly to the SBA by going on the SBA website and then applying for an EIDLP loan online. As opposed to the PPP as well, these loans are not forgivable. However, entities that apply are eligible for $10,000 in emergency assistance in the form of a grant within 3 days, even if the loan is denied. So that $10,000 can be another source of funding for the business in the form of a grant. And then the last question, I guess, with the EIDLP and then the Paycheck Protection Program is whether you can use both. And the answer is yes. However, each loan can't be used for the same purpose. So you can apply for both programs, but then you'll have to show the different uses for the funds. And then lastly, on this element, I wanted to discuss some of the questions that we received prior to the webinar. And one question we received is about the slowness of the process and how we get it back on track. And honestly, to get a government program and pass it by law and get it in place the way they have, this is beyond lightning speed for the government. However, because of the need of businesses to get funding now, all of us are feeling the tension of having any kind of delay in getting the program going. And one of the big issues behind this has just been the demand for these loans. The government, or the Congress, earmarked $349 billion for the program to be funded through June 30th, 2020. And as of today, over $100 billion have already been committed, which is over 1/3 of the funds committed in just the first few days. For the SBA, that accounts for over 10 years worth of loans that the SBA will normally process. Therefore, the demand is just exponentially greater than what the capacity has been for the SBA up until now. And so the key bottleneck in all of this is been getting SBA lenders up that can then process these loans and service them. And any existing SBA lenders were automatically approved for the program. However, other lenders that were interested, they had to participate in order to apply. Some of those are still in the process of applying, and then others are just coming online now. And then you have an issue with several of the national banks and other banks have varying requirements for their participation. Some of the national lenders will only provide these loans to people with existing banking relationships. Others are still evaluating whether they're going to participate. Wells Fargo ran into a cap on how much it could loan, and it needed the Fed to lift that cap, so we're still seeing how that's going to work out. And so it's just a big variation in what banks are able to provide what loans at this point. And so a key to getting through the backlog and for you to get a loan would be first probably to reach out to a lender that has an existing relationship with you, because that should speed up the process, and see if they can provide the loan. If they can't, then the other key is to research other lenders and try to find a lender that is already set up and running and available to process the loans. The last couple issues with this has just been the actual IT system used by the SBA. The E-Trans system was swamped on the first day or two of this launching, and that caused it to crash, which then slowed down the program. It seems to be remediated now, but basically the backlog that happened in the first few days of this loan has really caused the strain on the system. And how we're going to get through this and get it up and running properly is basically by building capacity with the lenders, and as the initial crush of the first businesses that are applying gets through, that hopefully they'll be able to catch up to that backlog. But then that raises another question, which is, let's say to get through the backlog and you're at the end of that and you're trying to apply for the loan, will there be any money left? And the Treasury Secretary raised this issue this week, requested another $250 billion for the program. However, there were issues that came up with Congress and it didn't get passed this week. So right now we're looking to see how Congress is going to handle the issue. My guess is because of the demand and the need for this, that they'll get it worked out. But at this point, we just don't know what the timing of that will be and when and how much of the funds will be available. But I would assume we'll get that worked out in the next week or so, just because of the demand for this to get approved. A couple other questions we had were about, one question was about what does it mean to show necessary to support ongoing operations in your certification. And the SBA hasn't provided direct guidance on what that means. However, I would think basically that one of the criteria is to show that you've been impacted by the economic uncertainty. And if you could show that you have been impacted and that you're going to be using the funds for those applicable purposes I mentioned, and you do use the money for those purposes, then I would think you've met the criteria for showing that your certification was necessary to support your operation. Again, I think the SBA wants to get the loans out to these companies, and they want to keep people funded. And so if you are impacted and you are using the funds appropriately, I would think you've met that definition that they're requiring in the certification. And then we had some questions on farms, and as we mentioned before, we're going to have a webinar that follows up next week that's more specific to the farm industry. But I wanted to give some answers to some of the questions we received, and one of them was questioning what programs are available to be used. And on the PPP program, the American Farm Bureau Federation and others have encouraged farmers to apply for the PPP loans. The Farm Credit System is one of the approved lenders for providing the loans. So the PPP loans should be available to farmers. One of the issues that has come up, though, is the EIDL loans. And traditionally, farmers were not able to apply for those loans for the SBA because there were other programs available to farmers. However, when Congress passed the expansion of the EIDL, the intent, according to the congressmen that have addressed this issue with the SBA, is to make this available to any small business, including farmers. And so right now, this is still an open issue, and as of this morning, I haven't seen it get resolved. But I do know that several U.S. senators and congressmen and the National Farmers Union president have reached out to the SBA to try to get this resolved. So again, I think between now and next week, we should have some updates on how that works with the EIDL. And then a last question we received is just how you can track an EIDL loan application. And again, if you Google the SBA and disaster loan assistance, that should get you to the page that the SBA has for providing disaster loan assistance, and that's where you would apply for the EIDL program. And then from there, you apply online, and once you apply online, then you can keep coming back online to check its application status. So if you have applied for the EIDL, then the resource to check on the status would be on that online application, whereas with the PPP, you'd be working with your lender. And then I had a couple minutes left, and I just wanted to touch real briefly on force majeure clauses. And these clauses are things that a lot of times you generally don't look at in your contract and you don't come back to very often. But here, it could be something that's important to you, either because you're faced with a major situation and you can't perform on a contract, or you're worried about a vendor or other contractor that may not perform, and you need to make sure that you're protected. And the background here is that, in essence, in a force majeure clause, it applies to any events that are outside the reasonable control of a party that prevents a party from performing its obligations under the contract. And these are interpreted differently from state to state. In some states, they're very restrictive, and they say that the force majeure clause only applies to the items listed in the actual clause. Other states are much broader, and California is honestly somewhere in between. And so if you're in a contract, it's important to, one, look at the governing law for your contract, and then two, look at the language of the force majeure provision to make sure that you're protected or you know how the force majeure provision will be handled. For instance, if your force majeure provision uses words like epidemic or pandemic or something that would really apply to what we're going through, then you've got specific language that would show that that's covered under the force majeure clause. If it has language about government action, then that might be something that would protect the business or apply because, in essence, businesses have been impacted by all of the stay-at-home orders and other restrictions the government has mandated. And then the last thing is a lot of force majeure provisions use language like events beyond reasonable control of the party. So again, the more specific the provision, the more likely the force majeure provision would apply to the contract. And then if you're using California law and you're in California, then generally, if you have to rely on broader language, the courts will look at whether there really was an interference that couldn't be prevented, even though you did everything you could to prevent it. And so therefore, if you don't have strong language and you need to rely on the broader language and you're in California, you'd want to make sure that you're taking reasonable steps to avoid the consequences of the force majeure event. And that would include things like promptly notifying the other party that there's an issue, making sure you're using commercially reasonable efforts to mitigate the issue, and then I would also want to see what happens if the event keeps going on, whether you just delay performance or whether the other party has a right to terminate the contract. And then on the converse, if you're worried about a contractor failing to perform, again, I think it's good to get ahead of the issue, see what the terms are in the contract, reach out to the other side if you're worried about performance and the force majeure provision applying, and then working out a plan with them to make sure that you can address any performance issues and make sure you're protected under the contract. And so again, with that said, I think it's just important to stay on top of your relationships with your contractors and others, make sure that you can perform on the contract, and then look at your force majeure provisions to see how they can either work for you or how you need to protect yourself in case you're worried about an issue with a particular vendor. And then with that, I'll turn my time over for our next host.
Hi, everyone. Thanks so much for joining us this afternoon. My name is Annie Amaral. I'm a litigation partner here at Downey Brand, and I wanted to talk briefly about the impact that COVID-19 has been having and continues to have on the courts throughout the state. The short answer is it's having all kinds of impacts, and the extent of those impacts varies greatly depending on which court you are in. So it is true that under Governor Newsom's shelter-in-place order that courts are exempt. In other words, courts and all of the court employees who work there are entitled to be going to work right now and carrying out their day-to-day functions. But the fact of the matter is that each of the superior courts in California are handling that status differently based on the scope of the crisis in their particular county. There are as many superior courts in California as there are counties, and there are all kinds of rural county-based superior courts that are treating this very, very differently than the courts that are located in more metropolitan areas. So, for instance, the best example I can give, which is, right in our own backyard here in Sacramento County, Sac County Superior Court has been closed entirely for several weeks. It is not accepting any sort of filings except for very, very limited emergency filings that relate primarily to an individual's personal safety. And even those filings are required to be submitted via Dropbox. Criminal issues are being handled on a procedural type basis, and what I mean by that is certain issues are still being handled, but for the most part, criminal and civil matters almost entirely are essentially put on pause while the shelter-in-place order continues. Now, that status for each individual county varies greatly, not just county by county, but also on a daily/weekly basis. So, for instance, there were a number of materials that we posted on the website before the call today. One of them was the public notice from Sac Superior Court about the implementation of civil essential services. This was effective as of last Wednesday, April 1st, and it's itemizing what the very limited operations are that the court is presently performing and for how long it's going to remain performing only this limited list. This says that the list of essential functions will continue through Thursday, April 16th. That is likely true, but just before we got on the call here today, the presiding judge from Sac Superior, Judge Hom, issued a letter to members of the Sacramento legal community talking about this letter or this order from just a week ago. And he's already talking about the possibility of another potential extension of this closure period. So the upshot of this is it's a moving target. The status of the court depends entirely on which court you are in, and it varies entirely from county to county, and then not just at the Superior Court level, but also at the appellate court level, and then again with the California Supreme Court. In an effort to bring some unanimity to the way that courts are handling this, the California Supreme Court has been issuing several orders to try and streamline things. One of the things that the California Supreme Court did was they suspended all jury trials for a minimum of 60 days. They did that on March 23rd. And it's unclear the scope of which trials are going to be impacted by this continuance, but there's no question that for at least the 60 days from March 23rd going forward, that jury trials, both criminal and civil, are suspended during that time frame. Now, there's wiggle room. There's language in there that, cases where good cause is shown may continue at an earlier date before that 60 days expires. But nonetheless, this order applies equally throughout all counties in the state of California. Something else that the California Supreme Court did earlier this week was they issued a series of emergency rules. This is the California Supreme Court along with the Judicial Council. And they issued a series of emergency rules to the California Rules of Court. There are 11 of them total. The bulk of these rules apply mainly in the criminal context, and so not necessarily germane to the folks who are likely on the call here today. But the last three rules do pertain to civil issues. and they address the questions about what's happening since everybody's on pause and civil cases that are already pending can't move forward, and many civil cases that want to get started can't get started until there's a court where they can file a complaint. What are we doing with the amount of time that's pending in the meantime? And so Emergency Rule 9 actually told the statute of limitations for civil causes of action. Any actions that are already pending are told, the statute of limitations are told from April 6th, 2020 until 90 days after the governor declares the state of emergency to be lifted. Emergency Rule 10 is similar. It doesn't toll the statute of limitations, but what it does do is it extends the time period in which litigants can otherwise typically bring their cases to trial. There's a statute that requires cases to be brought to trial within 5 years of the date on which they're filed. There are certain exceptions to that rule, and one of the things that the Supreme Court did here is they extended it blanket by 6 months. So for all civil actions filed on or before April 6, 2020, the time in which to bring the action to trial has now been extended by 6 months for a total time period of 5 years and 6 months. The other thing that these emergency rules addressed that's relevant to civil matters is they address the way in which depositions are being handled. Typically, when an oral deposition is noticed and taken, you get a witness to come to a conference room, either at your office or in a mutually agreeable place. You have your court reporter, you have a videographer, you're sitting across the table deposing your witness, and the witness has their attorney. And that can easily mean that there will be anywhere between 4 to 10 people in a room all sharing the same space. And there's been a lot of questions about how to conduct depositions now in this age of social distancing. So Emergency Rule 11 gives the witness as well as the deposing party the ability to require that the deposition be conducted remotely. It remains to be seen. This rule only went into effect earlier this week, so it'll be interesting to see how litigants actually plan to invoke this. I think it's definitely a strategy call on whether conducting remote depositions is advantageous or not, just depending on the circumstances of any given case. The other set of courts, however, that are also at issue are the federal courts, very, very different, handling things very, very differently than the way in which the state courts are handling them. And the main reason for that is because almost all federal courts now require filing to be done electronically. And so what that means is, although the court's websites say that the courthouses are closed to the public, what's happening is they're still accepting items for filing, and the judges are still working and theoretically getting through their caseloads based on the filings that are being submitted electronically. So it's a bit different than state court, which is not electronic yet, not in the exact same way. And so whereas Sac Superior, for instance, is closed for business and you can't submit a filing unless it's an emergency because they don't even have a Dropbox for hard copies, you can still submit your papers electronically to federal court. Now, they're not holding hearings. All civil matters categorically are being decided on the papers, at least here in the Eastern District. That's not, practically speaking, a huge difference from the way that a lot of civil matters are handled in any event in federal court, but nonetheless, it's now a matter of policy until the state of emergency is lifted. So the other thing to say about federal courts is, like the different counties throughout the state, each of the different districts are also implementing their own general orders and handling things a bit differently based on their locations and the status of the pandemic in the regions where they're located. Any hearings that are taking place are being done remotely, either telephonically or via video. And again, there are written policies in place requiring that that be the case. The other thing to talk about with respect to the way that this has been impacting civil pending litigation is what's happening with scheduled settlement conferences, mediations that were scheduled to occur. To the extent that any settlement conferences are mandatory settlement conferences as being facilitated by the courts where a case is pending, those mandatory settlement conferences are a function of how the court is handling the hearings in their locations. I think it's probably a safe assumption right now that throughout the state, there's probably no mandatory settlement conferences that are occurring, and if there is something that's on calendar, a litigant can likely ask to have it continued. But as for the privately scheduled mediations, I think that those are largely being taken off calendar, although the options have been out there to conduct them remotely, as one would expect under the circumstances. And it's really just being handled on a case-by-case basis, what the litigants prefer and how they think that it would be most effective to continue. But our experience has been that the mediation firms that are facilitating these are being very, very agreeable about the continuances, and although they're offering to conduct them virtually and remotely, anybody who wants to wait until they have the ability to participate in these events in person certainly have the ability to do so. That's a very, very high-level overview. Again, I can't stress enough how much of a moving target the present circumstances are for litigation in court. It depends entirely on which county you're in, and then again, whether you're in federal or state court. We've put several materials on the website relating to some of these different examples of the orders that are coming down, so you can see for yourself just how different it is depending where you're at.
Thank you, Annie. Appreciate it. This is Jamie Dreher again. Just before we close, there was a question to everyone about unemployment benefits coming from the state of California. We don't have anything further other than what's probably in the press, and I think the question goes to when the increase is supposed to happen, and Google says Sunday, but we don't have any better information than that. So thank you, everybody, for joining us. We're going to be signing off, and please look for information and reach out from us. Like I said, a week from today, Friday, we are going to be putting on a webinar that I'll call industry-specific, led by Dale Stern, to address issues in the food manufacturing, processing, and grocer space. So thank you, everybody.